Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis, and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble, and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook, and I just posted yesterday a really great interview with the president of Legacy Precious Metals, who is discussing why you need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903. All right, well, 2022 is going to be a critical year for America. AMAC, the Association of Mature American Citizens, along with their nearly 2 million members. The fight to stop out-of-control spending in the president's Build Back Better scheme is far from over, and Congress is plotting more legislation that could hurt our seniors. The midterm elections will be a battle for freedom versus socialism. Unlike liberal groups, AMAC is America's conservative, action-oriented 50-plus organization fighting hard every day here in Washington and across the nation for our seniors. So I'm urging you to choose AMAC now. You will receive all of the great membership benefits, including AMAC discounts on hotels, travels, and restaurants, and your membership will support your conservative values. So go to amac.us/Ellis. That's amac.us/ELLIS to become an AMAC member now.
As a constitutional law attorney, former senior legal advisor, and personal counsel to President Donald J. Trump, Jenna Ellis believes in the rule of law and the importance of integrity in our elections. And she's ready to tackle the big cultural and legal issues facing America. This is the Jenna Ellis Show. Here is your host, Jenna Ellis.
Hello, friends, and welcome to another episode of the Jenna Ellis Show. I'm Jenna Ellis, and today, of course, we have to dig into the order from Judge Cannon in Florida on the latest in the Mar-a-Lago raid case saga. And that order, of course, came out yesterday on Labor Day. And as I predicted on this show, it was a lengthy and very detailed and specific order that this judge decided to issue, 24 pages long, and it was much more specific and had a lot more content and precision than what she would have been able to do just orally from the bench if she had ended up making her ruling right after the parties argued late last week. So this is exactly what I predicted on this show. If you listened last week to my good friend John Solomon, we went through kind of the purpose and necessity of a special master, what we predicted. If you missed that episode, definitely go back and listen to that from John Solomon, my good friend, who's the editor-in-chief of Just the News. So this order came down yesterday on Labor Day, interestingly enough. Maybe she didn't want this to be too much in the news cycle. Don't know about that. But this order was excellent. And two big takeaways from this. First of all, the special master was granted that request. And so the special master is an independent judicial arbiter that will look at all of the documents that were seized from President Trump's Mar-a-Lago and will review them to make sure that there is nothing personal and, more importantly, there is nothing privileged. So that can be either the attorney-client privilege or, interestingly, the judge also referred to executive privilege. So while the Biden administration and the DOJ, and of course all of our fun and idiotic political pundits on the left have been talking about how executive privilege cannot be invoked by President Trump, and Biden can just waive that willy-nilly, and he has absolutely no legal basis to claim executive privilege. This judge is saying, well, not so fast. So that is going to be something we need to keep our eye on as far as after the special master actually looks through all of the documents that were seized and how exactly that person ends up saying, okay, here are the documents that fall under these privileged categories. And the second major takeaway as well is that no, it is not too late for a special master to be involved. There was a lot of speculation and kind of ha 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 from the left, of course, saying, well, President Trump's legal team waited 3 weeks, and now that the FBI and the DOJ has said, well, we've reviewed everything anyway, so what does it matter? They've already seen stuff that's privileged. Well, that may be true, but that doesn't mean that they can use it against President Trump. So this happens all the time as a regular course of business, if you will, in a legal context. And so if the prosecutor, which of course in this case is the DOJ, if they ultimately have something that for any legal reason cannot be used against the person that they're targeting, in this case, President Trump, then that is excluded from either the jury or from a grand jury or from their ability whatsoever to use this against the person that they're targeting. So just because they've seen the document doesn't mean they could use that information or that document, or even more importantly, anything flowing from the content of that document against President Trump. So while everybody is saying, well, who cares? Special master, no big deal at this point. We've got him anyway. Well, the law doesn't work that way, and it shouldn't, because privilege matters. Attorney-client privilege matters, and executive privilege also matters. And as I've talked about before, the Biden administration really should care about executive privilege, because even though they're trying to treat President Trump completely differently than any other president in American history by none of the rules applying to him, they should be concerned about the precedent that they're setting for executive privilege. Executive privilege exists so that advisors and counsel, not just attorneys, but senior advisors, close personal counsel, policy advisors, all kinds of people around the president can give him confident, competent, and sincere, forthcoming advice without being worried about this exact thing happening, that a future administration that is adverse, either politically or for whatever reason, against a former administration would use that advice in those discussions against him. And so, what we've seen throughout history is that presidents have had various questions about things. Can I constitutionally execute this particular executive order? What are my options in terms of a retaliatory strike, for example, if it's in a military context? I mean, all kinds of things that presidents need to know their legal and constitutional options, or even just the policy options or the advice. There's a difference between what can a president or any government actor do versus what they should do. Can is always the legal question. Should is always the policy question. Can a president issue an executive order? Can Congress, for example, pass this legislation? That is a constitutional question. That means, do they have the legitimate power and authority under the delegation of the separation of powers provided to that particular office? Can they do this? If the question to that is no, then that's it. No, you can't. You have no authority. But if the answer to that is yes, you can, then the political and the policy questions becomes should. Should we do this? And that, of course, is a matter of debate. And the questions of should are often, and I think really the sole area of inquiry that the very politically motivated Biden DOJ has against President Trump. Because, of course, their response to President Trump's policy questions and what he thinks should be done is going to be very, very dramatically different than what President Obama did, or now what the Biden administration is doing. Well, why? Because of course, they're two different political parties. They have different views on policy. This is why elections have consequences, why elections matter. And so even if there is a yes, you can, what you should do, that's really the bulk of the debate. And of course, we could go really far into detail with this as far as how Congress and the executive and even the judiciary has completely on both the state and federal level blown far past their limited legitimate authority in what they can do. And they often do just what they think they should do. Oh, I have a mandate to do X. Well, the Constitution says you can't. So it doesn't matter what you think you should do. You're limited. And that's the beauty of the American government system, is that we limit our government powers. We limit political actors from just doing what they think is in the best interests of America or society or whatever they're focused on. And we limit them to having specific, legitimate authority. So when we look at the broader context of this particular order, those two things first stand out. So first, again, that the special master was appointed and absolutely by law, everyone in the left is trying to say, oh, this is ridiculous. She had no jurisdiction to do this. This was completely outside the scope of what's normal. That's totally not true. A special master, for the purpose of this type of case, is to make sure that the DOJ and the government isn't reviewing and babysitting itself. It should have oversight to make sure that it adheres to the law. And the left loves to say, well, no one is above the law. President Trump isn't above the law. That's true, but neither is the DOJ. The DOJ is still also under the law. And this special master is going to ensure that the DOJ and the FBI cannot use privileged, personal, confidential information that they, under law, are not entitled to review or use based on Fourth Amendment protections, based on Supreme Court rulings, based on a lot of law, that they cannot use against any political target, whether his name is Donald Trump or anything else. And so when the left likes to say, well, no one is above the law, remind them that neither is the DOJ. And in fact, our Constitution and our due process protections that are specifically embedded into the United States Constitution in our Bill of Rights, the entire purpose of that is to make sure that the government, like the DOJ, does not trample on the rights of the private citizens like Donald Trump, even if they happen to be a former president or even if they happen to be someone that is a political opponent of this particular DOJ. And the founders understood, looking at the scope of history and how prior government in various contexts across world history have used and abused their prosecutorial authority and their government authority to target political opponents. And our founders did not want that in the United States of America. So I am very grateful that this judge, Judge Cannon, recognizes the importance of not allowing the DOJ and not allowing the government to oversee itself. And so what she says in the very first paragraph in the introduction of this order is that the cause comes before the court on the plaintiff's motion for judicial oversight and additional relief. Judicial oversight is so important. And that's exactly what the judicial branch is there for, to be the non-political branch, to make sure that the executive in law enforcement, in this case the DOJ, the FBI, and then in other contexts like the January 6th committee, for example, Congress, does as the two political branches, that they do not overstep their legitimate authority, that they do not act above the law. So judicial oversight is incredibly important. So she goes on to say, pursuant to this court's equitable jurisdiction and inherent supervisory authority, and mindful of the need to ensure at least the appearance of fairness and integrity under the extraordinary circumstances presented, the plaintiff's motion, in this case President Trump, is granted in part. So the court authorizes the appointment of a special master to review the seized property for personal items and documents and potentially privileged material subjects to claims of attorney-client and or executive privilege. That is very, very important. And I have to do a PSA here as well because there's been some either misreading or misunderstanding of the judge's motion here on some of our friends on the right who have said that this order then forbids or impedes or bans the DOJ from now moving forward with this case. That's not at all accurate. So the DOJ still can convene a grand jury. They can still proceed. What they can't do is use any evidence collected or taken, or in my view, stolen from Mar-a-Lago, from that raid, until the special master does his or her review and says, okay, this is the material that falls under the scope of privilege and personal items. You can't use any of this. Here's what's left. And then the DOJ would have to make their case on that and just that section. So that's really important. And then the judge goes into a really long history of relevant background. I would encourage you, go and actually read this 24-page order. It's very well written, very detailed. Goes through a lot of interesting things that we learned, of course. I was with the president and Senator Doug Mastriano in Pennsylvania on Saturday, and that was the first time that President Trump actually addressed the raid in the context of a rally and a more lengthy public statement. And one of the things that we learned from that, which was just disturbing, just so uncalled for, is that President Trump revealed that his 16-year-old son, Barron, his room was raided by the FBI as well. And in his words, how he described it was that Barron's room was not left in the same condition as it was prior to the FBI raid. And so think about this for a second. The minor child son of President Trump is now having his own bedroom, his private space, raided by the FBI based on this warrant, this search warrant that we've already talked about on the show, in my view, is so overbroad, allows any seizure of any documents from the beginning of President Trump's presidency in January 2021 all the way through, January 2017 to January 2021. So all of those 4 years, and any place that President Trump had the access or control of on those premises, which of course would include his minor son's room. But think about this. I mean, were the documents really, even if they fell under the scope of, some kind of valid warrant? And I mean, I don't even think that they were remotely targeting anything that was more than just a property dispute. Certainly nothing criminal that they've alleged. But let's just say that there were documents that they thought they were going to go get. I mean, is it even remotely likely that any of these would be in his son's room? Well, of course not. Or, his wife's closet. This is just a political intimidation tactic to say we can go into the most personal spaces of your private life, former president, and we can go in and we can make you know that we can have access and we can go in and you have no privacy anymore. And that is exactly what our founders did not want to allow the government to do when they wrote and ratified the Fourth Amendment to the US Constitution, which guarantees to a private citizen the right to be secure in your own home and have a right to privacy in your own home. Now, of course, the right to privacy we can talk about in other legal contexts, but the purpose to have the right to be free from unreasonable search and seizure is so that we prevent government from doing exactly what they did to President Trump. And so this is what I love about the judicial system and why I love being a lawyer, why I love being able to advocate to a court and advocate and say, this is unjust. This is unconstitutional. This should not happen. And stand up for the rights of people like President Trump, like everyday citizens. And why I love when the judicial branch does its job of oversight. And when the judicial branch actually says, no, government, you can't, you went too far. And now we are going to make sure that you do not use any of these ill-gotten gains against a private citizen. That is exactly what should have happened in this case. So the judge goes down and talks about in the discussion portion the jurisdiction piece, because of course the DOJ, and if you're on Twitter, you've seen a lot of commentary, and I doubt any of you, unless you're the libs and the left who are listeners, which we always enjoy. Welcome. Glad you're hearing the truth in a different perspective, but you will see some of this discussion that, this judge totally abused her authority. This is runaway. That's stupid. That is total BS. So the judge goes through and first talks about jurisdiction, why she has jurisdiction over this case. Go and read that section. If you have seen that, or if you're actually arguing that as a leftist, I'd encourage you, go and actually read that section, because she goes through the entire Ritchie analysis, which is that Supreme Court case that's talking about that. She goes into standing, of course, and why, of course, President Trump has standing, which that's the left's argument that they love to say, is that, President Trump can't file anything. He can never go to the court for relief. Here in America, anyone, it seems like, can file a case, and we have need for tort reform. We have need for all kinds of judicial reform, and everybody can go to court and have their case heard other than Donald Trump. They love to say that. Then the third section is the need for further review. And in that context, and under that banner, what the judge is talking about here is the need for further judicial review, for further judicial oversight. And she says, having determined that the exercise of jurisdiction is appropriate and the plaintiff has standing to bring the instant requests, then the court next considers the need for further review of the seized material as it relates to matters of privilege. And so review is further warranted, she says, as previewed for determinations of privilege. The government forcefully objects, even with respect to attorney-client privilege. And that little caveat from the judge is going, really? Even with respect to attorney-client privilege? Pointing out that the privilege review team has already screened the seized property and is prepared to turn over approximately 520 pages of potentially privileged material for court review pursuant to the previously approved ex parte filter protocol. So in plain terms, the government's position is that another round of screening would be, quote unquote, unnecessary. But the court takes a different view on this record. And that is fantastic. And the court has now, even, up to the Supreme Court, is starting to disfavor these special review teams, or these special taint teams, is what they're called, because the court is recognizing, and the judicial branch overall is recognizing, the runaway executive, the runaway law enforcement of reviewing themselves and saying, oh, please just trust us that we've done a review that's sufficient for due process standards. We, the adversary, to the respondent in this case, we, the prosecutors with the defendant, sure, just trust us that we're not going to cheat. Just trust that we're going to play the game fairly. And anyone who's concerned about fundamental fairness, the adversarial nature of the judicial process, and of course, the constitutionally protected rights of any citizen, of course, should not want the prosecutor reviewing themselves. You need an independent arbiter. That's the whole point of the judicial branch. So this is great. And just really quickly for the last portion of this, my good friend Margot Cleveland over at The Federalist wrote a really great piece that came out today talking about the judge's 24-page order that in her headline says, further calls into question the DOJ's targeting of Trump. And she has 7 takeaway bombshells in this article. And I would encourage you, if you don't have time to read the entire 24-page order, at least read this article from Margot Cleveland over at The Federalist, because she highlights 7 kind of top-line takeaways, which I agree with, and I think are really good takeaways beyond the 2 that I've given you, that are the special master is necessary, it's appropriate, it's proper. The DOJ should not be able to supervise itself. And the second, that it is still timely. It is still ripe. It is not too late because the special master can still exclude any privileged information from the DOJ being able to leak or use in a criminal prosecution, which hopefully they won't even get there. The DOJ really at this point needs to just drop this, and they need to come up with, hoax number 2000, million against Trump. Take up another hoax because this one is getting even more quickly debunked than all of their other attempts to get Trump. But here, very quickly, are Margot Cleveland's 7 top line takeaways. The first one is that President Biden was directly involved. She says in the order granting Trump's request for the appointment of special master, Cannon began providing a summary of the backdrop that led to the search. So throughout 2021, she goes through, how Trump and NARA, the National Archives and Records Administration, engaged in conversations concerning these records. Goes through the history, but it shows, and the language indicates that Biden did not merely defer to NARA, but asked NARA to give the documents to the FBI. So this really seems to suggest a more direct connection between Biden and the investigation into Trump, which of course he and his idiotic spokespeople have vehemently denied. That's interesting. Second, the timeline of Trump targeting is very suspect. So the second significant detail revealed by yesterday's order concerns the timeline of events. And why would the DOJ seek a grand jury subpoena for any and all documents bearing classification markings before reviewing the material provided, and especially when President Trump has said everything was declassified? That's a really interesting takeaway. Third, she says, the writer Margot Cleveland says, not so fast, Joe. Trump's executive privilege cannot be so quickly sidestepped. This is what we've already talked about, that the judge is acknowledging that there may be documents that are under executive privilege. So Biden can't just say, that's something that we're not even going to review. Number 4, members of the investigative team saw confidential attorney-client documents. So the court does take a different view on that record, and the privilege review team's report references at least 2 instances in which members of that team were exposed to material that was then delivered to the privilege review team and was designated as potentially privileged material. And the judge noted that those instances alone, even if entirely inadvertent, yield questions about the adequacy of the filter review process. So she expressed concern on that. 5, the DOJ seized a lot of personal material. Of course, they're not entitled to it. The most ironic part of this whole story is that while the left has been screaming, oh, Trump he's possessing information and documents he shouldn't have illegally, and oh no, the walls are closing in. It's the FBI here and the DOJ that are actually in possession of documents illegally based on this ridiculous raid. So it's always true, it seems, that anything that the left suggests that President Trump is doing, they're probably doing it themselves. And that includes illegally possessing documents and unconstitutionally and in violation of those constitutionally protected rights. So number 6, FBI suggested Trump committed a crime by returning a torn up document to the National Archives. That was very interesting. And Margot Cleveland says, this passage proves intriguing for 2 reasons. First, it appears the special agent in charge made a criminal referral of President Trump because some documents had been returned to the archivist that had been torn up at some point. This reference, in her opinion, screams witch hunt and leads to the second point, that the unredacted portions of the search warrant affidavit omit any reference to the torn documents. So rather, the unredacted portions of the search warrant affidavit speak of the government, quote, conducting a criminal investigation concerning the improper removal and storage of classified information in unauthorized spaces. So none of the unsealed portions reference a second basis for the referral, such as Trump returning torn documents and that's somehow obstructionist or illegal or something else that they want to look into. So this really does make the special agent in charge and that referral look inherently and totally political. And finally, number 7, the leaks look really bad too. So those unfortunate leaks to the media provide further proof that the political nature of this entire affair in the 3 weeks' time since the Mar-a-Lago raid has happened and all of those leaks have escaped are so obviously tailored to taint the public perception and the court of public opinion. Because this ultimately, and this is why, this is a good number 7 to conclude on, this is always what it's all about. It's never actually about law enforcement. It's never actually about, some crime. It's never about collusion with Russia. It's never about, anything else other than completely and totally trying to destroy President Trump's credibility and image in the court of public opinion. This is political right ahead of the midterms and right before President Trump announces that he will run for office in 2024, which I believe that he will shortly after the midterms. And they are trying on purpose to tire out the right to just say, you know what, forget it. We don't want to back President Trump. Let's go with somebody else who isn't, just this difficult and has all of this media problem. And also for the people who are somehow convinced by all of this BS to hate Trump even further. And so the response to this should be a doubling down and to say, we are not going to allow the DOJ and the political operatives of the Democrat Party to tell us, conservatives, who we should have as our nominee simply because we're tired of all of this in the media. It's President Trump who is dealing with all of the raid and the insanity. We have to decide who our nominee is based on the character, nature, and quality of that person themselves. Because you don't think that as soon as, the Republican Party would say, forget it, fine, we're moving past Trump, that the left wouldn't just then automatically start doing all of this crazy BS to the next candidate? Of course they will. This isn't going to end just because the right no longer supports Trump. They want you to think that, but that's not the way that they operate. So we need to say, we don't care. We don't care what your hoaxes are, what your stupid distractions are, and what you want us to think about the court of public opinion. We make our own decisions. And we make our own decisions who we want to support for our nominee and who we want to elect to represent us in every office, from the president all the way down to state and local level. So let's all be very thankful for this special master order. It's going to be very interesting to see what comes from the special master's review and whether or not there are more pages than 520, because then that would show very clearly that the DOJ did not do a good job of overseeing themselves. And of course, we will cover everything here on the Jenna Ellis Show as this case continues. Everything else, very, very important to continue seeing how the judicial branch operates here. And of course, make sure that you are subscribed to this show so that you get every episode as it drops. You can subscribe wherever you stream, if it's audio on Apple, Spotify, iHeart, at thejennaellisshow.com, and of course on Rumble. And, if you still like YouTube, fine, we're up over there as well. But I will see you tomorrow with a very important update from our good friends over at Project Veritas. That will be a very important show, so make sure that you are subscribed before tomorrow, and definitely share this episode with all of your leftist friends to dispel all of the crazy court of public opinion myths and make sure that you have the truth of what's actually going on and what our Constitution and our rule of law protects, which is that, yeah, President Trump is not above the law, but neither is the DOJ. Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis, and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble, and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook, and I just posted yesterday a really great interview with the president of Legacy Precious Metals, who is discussing why you need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903. MyPillow is having their biggest sheet sale of the year. You all have helped build MyPillow into the amazing company that it is today. Now, Mike Lindell, the inventor and CEO, wants to give back exclusively to you, his listeners. The Percale bed sheet set is available in a variety of colors and sizes, and they are all on sale. So, for example, the queen size is regularly priced at $89.98, but is now only $39.98 with our listener promo code Jenna, Jenna. So order now, because when they're gone, they're gone. The Percale bed sheets are breathable and have a cool and crisp feel. These come with a 10-year warranty and a 60-day money-back guarantee, so don't miss out on this incredible offer. There's a limited supply, so be sure to order now. You can call 1-800-564-8475 and use the promo code Jenna, or go to mypillow.com/Jenna. You can click on the radio listeners square and use the promo code Jenna. That's Jenna. Thank you so much to all of Mike Lindell's listeners and listeners of this podcast for making sure to support MyPillow and using our exclusive listener promo code Jenna. That's Jenna.